Buckingham Palace. The Queen talked about the shared heritage and common values between the U.S. and Great Britain, and the President called D-Day one of the greatest undertakings in history.
Her Majesty inspired her compatriots in that fight to support the troops, defend her homeland, and defeat the enemy at all cost.
The Pentagon is telling the White House not to politicize the military after the USS McCain incident. Acting Defense Secretary Patrick Shanahan told his chief of staff on Friday to speak with the White House military office to reaffirm his mandate the department will not be politicized. The House Judiciary Committee is announcing a series of hearings focusing on the Mueller report on Russian interference in the 2016 presidential election. Stocks are closing mixed as the tech sector is declining today. The Dow Jones Industrial Average added 5 points. Tom Roberts, NBC News Radio.
I always hear from our clients who hired another firm that they wish they'd hired DNA Financial first. Don't have regrets about your IRS tax case. Just hire the best in the first place.
One owed $150,000 to the IRS and had spent thousands on another firm. We stopped the levies, negotiated a payment plan, and had their penalties forgiven.
And while every case is different, we guarantee that we'll find your perfect resolution and get it done right.
For a free consultation, call us at 866-201-0156. That's 866-201-0156. Then you can say, DNA did right by me.
Rent-A-Center is lowering prices like way down. Now for $19.99 per week, you can get an Xbox One or PS4. And what better way to enjoy those consoles than on an Altoro Dune sofa with a reversible chase? Again, for $19.99 per week. $19.99. Rent-A-Center has a worry-free guarantee, free same-day delivery, and competitor price matching. Rent-A-Center, located in the Tri-City Shopping Center in Redlands, where the 10 and the 210 meet between the Alabama and Tennessee exits. Rent-A-Center, $19.99 per week. Sale price is valid until October 28th.
If you're looking for a full or part-time sales position and you have radio, TV, or print media experience, KCAA has a great opportunity waiting for you that pays the highest commissions in the market. KCAA is the only station in the IE that broadcasts on 3 frequencies, so advertisers receive 3 ads for 1 low rate. This makes KCAA a must-buy for every local business. If you're interested in a sales position with us, email CEO@kcaaradio.com.
Del Walmsley here. The first thing you're going to have to learn is that until you stop expecting our politicians or anyone else to change your life isn't going to change. The only person who can change your life is you, but you need to know how. Listen to my show, the Del Walmsley Radio Show, where the hype ends and the help begins. Right here on KCAA, now broadcasting on 1050 AM, 102.3 FM, and 106.5 FM, the stations that leave no listener behind.
Miss your favorite show? Download the podcast at kcaaradio.com.
Herb Dodell.
Well, good afternoon, ladies and gentlemen. A little on the loud side. That's good. Anyway, one of the things that we do with the show, we try to do with the show, is mix things up. We say this every week, actually. Now, some weeks we talk about practicality. Some weeks we talk about cases. Some weeks we talk about guidelines. Some weeks we talk about spirituality. Like the last month or so, we've been doing pretty much an exploration into social issues. We've had adult stars here. We've had Roger Stone. And I've got commitments now for some people for July, which would be very interesting.
Oh, we got to talk about July, Judge. But we'll talk about off the air.
Okay.
But
I guess there's no pleasant surprise coming with this thing.
Well, July is usually when I take a couple weeks off, but we'll talk about it off the air. We'll work on it.
But today I want to talk about practicality.
That's practical.
And guidelines.
Okay. Go ahead.
Because one of the things we want to do, and the reason I wrote the book, which of course is called
From the Trench to the Bench.
Yeah, the reason I wrote the book is to help the public understand what's going on in their lives if they end up caught up in the legal system. And generally speaking, with the exception of small claims court and sometimes restraining orders where the rules are a little different, the rules are pretty well established and have been established for hundreds of years. It's basically including what's called a body of evidence. And so today we're going to talk about both the criminal and the civil. The criminal is going to take very, very short, less than 10 seconds. There is no discovery in criminal law. Discovery is a term that denotes what I refer to in the book as the Christopher Columbus phase. You know, a lawsuit starts with filing of a complaint, a civil complaint. Criminal complaint is basically the same thing, but in a different form. And when you start with a complaint, the complaint really says what the other guy did wrong. And if you're defending, you're saying you've got a defense to all of that. And in some cases, you can sue them people back on the grounds that they did harm to you, and then you end up with a finger-pointing exercise. But the way it usually starts is with a complaint. And there's methodologies that deal with that phase, which is called the pleading phase, Pleading. And it's kind of interesting. I wondered why I call it pleading, because at the end, it's called a prayer. It says prayer for relief. That's what it's called. So the pleadings are generally very technical.
You're talking about civil right now.
I'm talking about civil. Well, criminal, the same thing. Not as much. For example, there's a concept called a demurrer, Demurrer. We talked about that a couple of shows back. And that's basically an attack on the other person's pleadings, saying even if you're 100% right, you can't win because it violates the law. The statute of limitations is run. I don't know enough about what you're claiming because it doesn't say that. It's not clear. You can require the other side to clarify their pleading, their complaint.
How about even a bad search warrant or something like that?
Search warrants obviously come under the criminal law only, and there are methods for attacking search warrants, motions, what they call motions to quash.
Right.
And the big motion in criminal law dealing with the seizure, actually search and seizure, deals with one of the constitutional amendments. And there's an attack on the probable cause requirement in a criminal case. In other words, in order to search and seize something, according to the Constitution, you have to have what's called probable cause. And probable cause depends on who's looking at it. Now, I can tell you that I remember early on in my career, there was a judge in one of the courts, I won't mention which one it was. She was a rubber stamp. No matter what you had, she signed it. The cops would make sure that that's who they were going to go see because it has to be signed off by a judge. She signed everything. Anything, everything.
Did some of that stuff get overturned?
Yeah, it's called a motion to suppress.
Right.
The California case numbers are basically 1538.5 of the California Code, Penal Code. And you can attack it on the grounds that it was an illegal search. In other words, if they just break into your house without what's known as a warrant, everybody has heard that term.
And let me ask you about a warrant, because a lot of people don't know a whole lot about warrants. How does I guess a law enforcement officer or entity get a warrant?
Simple. You have the prosecutorial agency, usually the district attorney or the city attorney. What they do is they put together a declaration in support of an application for a warrant. Now, there's two kinds of warrants. One's a search warrant, which allows the law enforcement agency to go to a particular place and search the premises.
But they have to have probable cause. How do they get probable cause?
The judge has to sign off on it.
Right.
To get a warrant, the judge has to sign off on it. Although I can tell you this, I used to issue arrest warrants when somebody didn't show up.
Right.
Generally, there was one we would call an oral appearance of the debtor in a civil case. If the debtor didn't show up, I would issue a warrant. I didn't need any probable cause. The person wasn't there, and the warrant allowed law enforcement to go pick that person up wherever they could find him or her.
But I'm talking about more of a search warrant, like
probable cause is basically is there a reason to believe that a crime has been committed and that person committed the crime? That's the basic.
So they have to have some sort of evidence to support the search warrant.
Right, but the thing is about search warrants generally is there's a rule called hearsay. People have heard that term over and over and over again. Most people don't know what it is. In fact, a lot of judges don't know what it is because there's so many exceptions to the hearsay rule. Hearsay is generally an out-of-court statement made by a third party being offered for the truth of the matter, where that person is not in court to be cross-examined. That's the basic general principle.
So let's just say you're dealing drugs in your house or somebody alleges that you're dealing drugs, and they're your neighbor, and they see people coming in and out of your place. Can they go to the cops and say, "Hey, I think they're dealing drugs over there"? Is that basis for a search warrant? Could that be basis for a search warrant?
Could be if there's enough corroboration. The word that's being bandied around right now is called corroboration.
Right.
Because oftentimes you get a swearing contest. You know, A says one thing and B says another.
Yeah.
And how do you know who's telling the truth? Well, you look to see. In fact, in many cases required, like a conspiracy case, you have to have what's called corroboration, meaning some other independent evidence, whether it's testimony, a document, a record, a film, whatever it is. And so if somebody reported that the next door neighbor was selling drugs, they would say they live there, they're there every day, and people keep coming and keep going out. They stumble in and they stumble out.
Right. No, I'm saying all night long. Yeah.
Well, they go to law enforcement.
And then what they do?
Law enforcement takes the information that they got, they interview the witness, and then law enforcement goes to the prosecutorial agency. I think I mentioned this. I'm sure I did. When I first started out in the DA's office, when I was a former deputy district attorney, I was in the office. The cops would come in, basically lined up. You know, they'd sit outside, and it was like taking an appointment. They would come in and they would tell me the story. You know, a lot of them got a little embellished.
Of course.
They wanted to get the warrant. They wanted,
well, of course. They're not going to.
Well, they embellished some things, no question about that. And they would have to convince the filing deputy, that's what it was called. I was called the filing deputy. You have to convince the filing deputy that there's sufficient legal basis. And what you do, not necessarily with regard to search or arrest warrants, is you analyze it and you say, okay, if I got to go to trial, this is what I got.
Can I win?
Beyond a reasonable doubt. And if you say to yourself, I don't think I can prove this case, it's called a no file. So people can be arrested, could even be arraigned or scheduled for an arraignment, and you show up in court and you look for the file, there's no file. The DA has declined to prosecute. I mean, that's your dream. And a lot of times the client is not told that's what happened. They think the lawyer goes into chambers, the lawyer comes out and says, you're free, you can go home now. I can? Yeah. I got your case dismissed. Well, it was a no file.
Give me $5,000.
It was a no file.
You ain't gonna tell him that though.
Absolutely not.
Of course not.
In fact, there used to be a famous lawyer. He's now passed on. We used to do all that all the time. He would go into chambers. He'd come back and he'd make all these deals. The client never knew, but he made a lot of money.
I'm sure he did.
He was a very successful guy. We're going to talk about the second phase of a case. We call it an anatomy of a case, if you will, after the pleadings, and we'll talk about that right after the break.
1050 AM, KCAA.
Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, he has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system, so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
You know, I was listening to the break, and I don't listen to it very often. It's the same every week, but it's really amazing how little the public knows in terms of how the system really operates. It truly is an amazing thing. The public is really in the dark, and that was one of the reasons I wrote the book, and that's one of the reasons I'm doing the show, is to kind of let them know how it really works, so they're not emblazoned by what they hear from commercials and otherwise.
I mean, my dad was a criminal attorney for 30 years, and when I had to go to court on a couple things, I was still sort of intimidated, didn't know what the hell was going on. So it is very cool that you're doing this show and you wrote the book, because a lot of people really don't know, and you sort of freak out once you have to, whether you're getting arrested or you're getting a case filed against you or something like that, something happened. It's very intimidating.
Well, it's I discovered along the way, early on when I first started writing the book, I saw a lot of what they call pro pers. A pro per means pro per persona, meaning by representing themselves. And you really do see the difference between self-represented people and people who have lawyers. Some lawyers are not so terrific. Some lawyers are really very, very good. I think I've told this story before. I'll tell it again, because it really is representative of what happens in the system. There was a very, very famous basketball player, NBA, long time, very, very successful. He
played for the Lakers, right?
He did play for the Lakers.
Okay, it's like the same guy I'm thinking of.
It is the same guy.
Okay.
And
it wasn't Magic Johnson, by the way.
No, it wasn't. To Magic Johnson's credit, Magic Johnson would never have been in the hole that this guy was in.
No, I know.
And what happened, this guy was making a lot of money even in those days, in the day, as they say, and he bought a $7 million house. We're talking probably 15 years ago, 20 years ago. And things didn't turn out so well for him. I guess he took the money that he made and he either spent it or did whatever he did with it.
Which is bizarre for this guy.
It was, because it was really out of character for him.
Totally.
I found out a lot about him afterwards.
Yeah.
In fact, I didn't really know much about him until the bailiff came in to the chambers and said to me, who's that that's out there? I said, no, and he told me who it was. And I looked at the docket sheet and there's the guy's name. I recognized it right away. And I said, gee, what the hell is he doing here?
Right.
This is an unlawful detainer. I was sitting in what they call unlawful detainer court.
Which means what? Let the people
Landlord-tenant.
Okay.
Not so much landlord-tenant. It's repossessions, mortgage debts, and all of that.
So he was
there as a defendant, and the bank was there with their lawyers, and they were looking to throw him out, basically.
Wow.
A victim.
Wow.
And that's a serious thing. And unlawful detainer court is a little different than some of the others because it's very, very hyper-technical. Very hyper-technical. The rules are very, very specific. There's a whole body of law that deals with that, and the same lawyers appear on a regular basis. But a lot of times the public comes by themselves. Here's this guy, world class.
Yes.
And he's by himself. And I read the papers, his response, and I said to myself, he's got a defense.
He wrote it out himself?
Wrote it out himself.
Okay.
Representing himself, pro per.
Wow, that's crazy.
Pro per. So I read it, I said, what he could have done in retrospect, he could have filed his own complaint. You can't do it in unlawful detainer court because you can't have a cross complaint, but you could file a separate lawsuit alleging a breach of contract or whatever, as long as there's some merit to it. And what happens generally, and I know this because I went up and I consulted with the presiding judge over it because I really didn't know the first time it came up. I didn't know what way to go with it, so I called her. And basically, if you have a case in another court, that case will take priority over the unlawful detainer. But unlawful detainer cases, there is a required expeditious process. Everything's short, 5 days instead of 30 days. Everything is quick because they're trying to get the protection for the owner of the property.
Get the person out of there.
Right, and so you don't get much play. You can buy maybe 30, 60 days if you know the little routines and how to do it, like filing a demurrer on an unlawful detainer case. I probably heard 1,000, maybe 2,000 unlawful detainer cases. At least. And every demurrer that was ever filed, I overruled. I don't think I ever granted one because it generally it's worthless. It's just looked to buying time. And they know that they can buy 35 days.
Right.
And so the banks got smarter and they came in and made what they call ex parte motions to shorten the time, to have the demurrer heard earlier. So there was no benefit. And if the demurrer was overruled, which it was most of the time, I gave him 5 days to answer. Answer is the response to a complaint. That's what it's called. It's called an answer. And so I look at this guy and I'm saying, he should file, according to his factual allegations, he should file another claim. This was in one of the outlying branch district courts. And I said, what happens is, if you believe there's a reasonable basis that he or she could prevail in that other case, the breach of contract case, or in this case, they didn't give him a loan modification, and he had some basis to argue that they discriminated against him.
He was trying to get a loan modification?
Yeah, he was, and he probably qualified for it. I never got into the real facts, but he probably qualified for it. They didn't give it to him.
Oh, okay.
They were going to grab the house.
Right.
In fact, I saw Mary Poppins on the plane last night coming home from New York.
Mary Poppins?
Yeah, that was about repossession of the bank's house. And so you watch what the banks will do. They're going to take the house. They're going to sell it, and they're going to make a profit on it.
Right.
Or whatever they're going to do.
And then is he still in debt with that? Would he still owe the money on the house?
Well, yeah, you get a monetary judgment.
Okay, so they're going to...
Although there's something called a purchase money mortgage in California, which doesn't allow for any deficiencies. But that's a subject for another day, much more complicated than we're going to talk today. So I said to myself, if he made a pitch that he'd filed another complaint, I would have looked at it, and if I thought that there was real merit, I would have stayed the unlawful detainer case until the other case was decided. It could have bought him a year or two. In fact, I did buy for another client, not to say buy. I had a client in my private practice who was also a judge, as a matter of fact. I kept him in there for almost 3 years.
A judge was defaulting on his...
Oh, it's a long story.
Okay,
it's a very...
Let's stay with the Laker.
Very long story. So the bottom line was, I had already known the answer because I had already called Judge House, who was the presiding judge at the time. And I said, can I do that? Can I stay it? Because UD cases are supposed to move along really quick and there's no cross complaints.
And you felt bad for this cat?
I did feel bad for him. I learned, I talked to the bailiff, and he made some comments about what this guy's personal beliefs were.
Oh, yeah. It's very famous, actually.
Yes, he
was.
Very
famous personal beliefs.
And he was very, very nice. He was a very soft-spoken, very pleasant guy. And I said to him, do you have a lawyer? And he said, no. And I'm looking at it. He has a possible defense. I could possibly have stayed the action. I said, I think you might want to consider, getting a lawyer. You may have, because, one of the things that we're not allowed to do is give legal advice. Absolutely forbidden.
Of course, you're a judge.
Every now and again, you can give them what they call procedural advice, because it's not really an issue of law.
Right, how to handle things.
You have 30 days to do this. You can do that.
Right.
But you can't tell somebody, you got a good shot of winning this in another court, and I could stay it because the bank would be jumping up and down and screaming,
of course.
And the reason you don't give legal advice is because you're taking sides.
Yeah.
And you can't do that.
So what did you tell him?
So I said to him, I'm going to give you 2 weeks. I think you should consult with an attorney.
Oh, you actually said that?
I did.
And what did the bank say to that? What are they going to say?
I got news for you. In the courtroom,
you rule.
That's right. You got something to say? Start it with Your Honor, with all due respect. Every time you don't agree with the judge, you hear it starts out with all due respect.
Yeah.
There's no respect. The bottom line was there was nothing they could really do about it. I was going to grant it. I did. And so 2 weeks later, he's back. I'm figuring if he go consult a lawyer, he's going to figure out that maybe he could use this methodology. And what I did, when I would grant these stays, which I did in occasional times, I'd make them put up some rent. So they weren't staying there free during the processing of the other case. Otherwise, everybody would do it. And so they'd have to put, in fact, I would often require them to pay it into the court, the rent into the court, or the reasonable value. This was a repossession. It wasn't a rent. So I would have required him to put in maybe the mortgage payments every month. And if he defaulted, I would have invited the bank to come back and make a motion to expedite. There's procedures.
Right.
Which you learn from sitting there every day and looking at, on some days I'd have 40, 50 unlawful detainer cases. Literally, 40 or 50 a day.
It's crazy.
A lot of them were resolved because the landlords or whatever, they had a set pattern of what they would do. They would say, okay, if you're out by such and such a date, we'll dismiss and we won't ask for the money. You know, they worked all these deals out. We'll seal the records with the court's permission and things like that. I always granted a sealing, because that kept them from being precluded from getting other rentals. Because if the landlord checks your record and sees you just got kicked out from somewhere else,
They ain't gonna rent
your
you.
chances are not that great.
No.
So we have a lot of discretion to do that.
So what happened?
So the
what
bottom
happened
line
there?
is 2 weeks later he comes back.
Yeah.
No lawyer.
Oh my God.
He made a kind of an effort to plead her out, but he never got to it. And I looked at it and I said to myself, I don't really have any choice. We don't have any choices, really. If you follow the law, which is what we do,
Yeah.
you can't, and I can absolutely say this, I never let my emotions ever interfere with the rulings that I made.
Even though you wanted to help this cat out.
I did. I really wanted to help him. He wasn't the first person I really wanted to help, but I couldn't.
Right.
And so I basically issued a writ of possession, and they served him with a writ of possession, and out he went. And he waited for me outside of the courthouse when I got off the bench. He was standing there outside, and he wanted to talk to me. And I said, you know, I'm not permitted to have what's called an ex parte communication because the other side is not here. I can't do that, so I can't talk to you. But I will tell you this. Time is allowed to do certain things. You need to consult with a lawyer. You may have some remedies available. I wasn't going to tell him what it was or anything. But you can do so. I never heard it again. I think he just got kicked out. You know, they came in, locked the doors, locked him out, and that was the end of him. But it said to me,
crazy.
It said to me, there's so many people that are out there in pro per that have no real clue. That doesn't mean that you're going to do better because you have a lawyer. I've seen some pretty incompetent lawyers. I'm telling you, I've seen incompetent lawyers. I wonder how they got a license. I truly do. I had this one case where the guy was arguing the constitutionality of a statute. I had to decide whether the statute was constitutional. It was a financial code section allowing for unlimited interest if you had a license. And I really wanted to help this guy out. But he didn't plead it. A pleading is, you know, the complaint or an answer. And he didn't plead it. And I said to him, you can't argue that. It's not in your papers. I'm not going to think about it until you do it right. So we'll talk about what happened right after the break, and then we'll get into discovery.
That's too bad about the Lakers, though.
Yeah, nice man.
Yeah, he is. He's a good dude. He was a good player, great player.
Oh, fabulous player.
Won championships with the Lakers.
Yes, he did.
All right. Well,
Tell him sell the ring.
sell the rings.
He had several. I think he had several.
I know. All right. We'll be back after this with Judge Herb Dodell.
NBC Talk Radio, 1050 AM, KCAA.
In his book, From the Trench to the Bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, he knows the legal system. He has the inside information that you need to pick a lawyer, and he's here to give it to you. No matter what you're facing that makes you think you may need a lawyer, Judge Herb will shed valuable light on your situation and reveal your best options and many secrets of how the judicial system actually works. To find out more about how the legal system really works, you can get your copy of Judge Herb Dodell's eye-opening book, From the Trench to the Bench, at Amazon.com.
In the break, we use the term demystifying the system. So I said to myself one day, somebody needs to write a book to tell the public how it really works. Not from the deep academics, but in general terms, easily understood by the lay person, so they know what direction they're going in and can be better prepared for what might happen to them. If they know that it happened to somebody else, because we described that, they may be able to prepare against that happening. If this guy had read the book and he had read the chapter on unlawful detainers, he might have known all he had to do was file another suit in another court. He didn't know that. And I kept seeing this happening on a regular basis. So the guy with the constitutionality, I said, you can't argue it. It's not in the papers. I said, I'll tell you what I'm going to do. You know, the plaintiff, which was a lender, had to prove that they had a license to charge unlimited interest. There's a section that allows for that, believe it or not. And
that sucks.
I said, I don't see a certified copy. Well, there's a Xerox, a photocopy. I said, no. I want a certified copy to show you have a license. Since you don't have one, you don't make your requirements either. So I'll tell you what I'm going to do. I'm going to continue the case for 2 weeks. I was always into giving 2 weeks. I figured there was enough time for them to get it together. I'll give you 2 weeks. You need to go back and amend. You make a motion for leave to amend, which you're asking the court to change your pleading, and I'll probably grant it. And now you'll have it subject to the court's analysis and ruling. And you bring back a certified copy of your license that you can charge whatever interest rate you want. 2 weeks came. They came back. The guy did a half-assed job on pleading the constitutionality. It was junk. I mean, it really was. And the plaintiff, the lender, didn't bring back a certified copy. So I said, I'm not even going to get to the legal issues here because you didn't satisfy the burden that you have to prove with a certified copy. But these were two incompetent lawyers. Because it wasn't a tremendous amount of money. And I did, by the way, I wanted a fine for the defendant. I really did. In fact, I think I told the story. We have what they call research attorneys. If you think that the judge does all the analysis, guess what? We don't. It's done by a research attorney. They're full-time employees, and that's what they do is they go through all the papers and they write us what's basically a memo.
There's a summary, or
it's a summary and a recommendation based on section such and such and such, and that's what you should do such and such and such. And most of the time you follow it because you have so many files that you can't start over unless there's a specific issue that says, okay, I really want to do this myself. Because I have done that. I read memos from research attorneys and I didn't agree, and I went back and hit the books myself and made decisions that were different. But generally speaking, the more less active, I don't want to say lazy judges are just going to basically take the memorandum and stamp it, and what they recommend is usually what's accepted. And so I had actually sent this research attorney over the weekend. I had him work over the weekend. I'll never forget it. And he was pissed.
Of course he was.
I said, I got to make this ruling next weekend. I said, you gotta go get to the research on this constitutionality is a comprehensive analytical thing that has to be done.
Did he get paid overtime?
I don't know. but he was a nice guy, and he called me on Sunday at home, and he says, there's nothing you can do. It's constitutional. There was a case that went back about 30 years and it ruled the constitutionality of it. And so even though I wanted to help this guy, he was paying 99% interest.
99% interest. Come on,
I think it was 99%. Yeah.
This is crazy.
I had to sustain it.
That's insane, man.
I didn't really have to sustain it because, believe it or not, a judge can say that a contract is unconscionable. In other words, the terms are so unfair that you don't have to enforce it. And so every now and again, especially when I was in small claims court, I would take a look at some of these and say, it's unconscionable. I'm not, usually with the collection agencies. What's your rate of interest? 54%. I said, no, not in this court, it's not. And I would knock it down to the statutory rate plus some.
So you could knock it down?
I could.
Right.
And, any judge could.
No, I'm just saying, I mean, a judge can knock down.
Yeah, you can. It's unconscionable.
That is unconscionable.
99%. I actually ruled in favor of the lender.
Oh.
That didn't want to. Definitely did not want to, but did. And so I kept saying to myself, there's so many people out there that are unrepresented. Criminals even worse. But criminal is a difference because if you haven't got any money, you get a public defender.
Right.
You don't get a public anything in a civil case. You're on your own.
Well, lawyers do take it on contingency.
Yeah,
So,
but
I mean,
still,
but still,
yeah, but
it-
you have to
not
have
if
you have to have a contingency case to do that.
right. You can't be the defendant. It's
There's
hard
no
to get.
contingency.
Yeah,
There's no
yeah,
contingency on a defense
for the
case
defense. Yeah, that's what I was going to say.
unless you have a cross complaint that you think is really good,
Yeah.
and you're willing to gamble on winning the cross complaint.
Or actually, the lawyer's willing to gamble.
And that's the secret to success in the contingency business. I was talking to a guy today about a referral that I got, probably from the show. Somebody had lost their house in the Paradise Fires. And I was talking to this lawyer that he's on our show, as a matter of fact, Jeff Nidrich.
Yes.
And I said, sounds like a pretty good case. He says, look, we only make money when we got contingencies that pay. If you take a contingency case and you spend money on expert witnesses and you don't win, you don't get paid, number one. But the worst part is you don't get your money back for the out-of-pocket expenses.
The lawyers don't.
So the lawyers can either hit a home run with the bases loaded and make a real killing on it, or they could get wiped.
Yeah.
You get a big case and lose, you're in serious doo-doo. That's some of these firms could take it in the shorts and they're gone. So when you say contingency, that's not a do-all end-all, believe it or not. I'm not really wild about some of the contingency kinds of deals that are out there. But getting back to the point I was trying to make, which is that I felt that it was time for somebody to explain to the public in layman's terms what really goes on and what they could do. And that was one of the motivations in writing the book. And I've done that. I mean, I explain everything like I just did the demur, all kinds of motions. If you're a plaintiff and your lawyer's doing all of these things, don't you want to know why they're doing it, especially if they're billing you for it?
Yeah, especially the language. I mean,
sure, you want to know. In fact, one of the things we talked about how to pick a lawyer here in the last couple of shows. One of the things you want to do is you want to ask that lawyer, what does all this mean? What do you mean you're going to make a summary judgment motion? Well, what's the summary judgment motion? Well, it's about $25,000.
Don't worry about it.
And they usually are.
Yeah.
They usually are.
That's crazy.
This is the insurance defense lawyer's dream. Summary judgment motion, it means that no matter what, you win because there's no issue of fact.
The lawyer wins.
The lawyer, it's a mother load for the lawyer.
That's what I'm saying. The lawyer, it doesn't mean that the client wins. It means the attorney wins.
And some summary judgment motions are hard because if there's any issue of material fact, the word material is very important. Ask Roger Stone about that. If there's a material issue of fact, you cannot grant the summary judgment motion. I think when I was doing law in motion, I was assigned to law in motion at one point, which ruled on summary judgment motions, demurs, motions to strike, and things like that. There's a heavy burden because you're ending the case. You grant the summary judgment motion, not a summary adjudication, which is a part of a complaint. You grant that the case is over, and it's done, and it's on to the Court of Appeals. And so I was very conservative when I was reading summary judgment motions. If there was any real legitimate material issue of fact, I denied the motion. So I probably denied most of them because it really was just a fundraiser for the insurance defense people. They made a lot of money on these summary judgment. I've seen them wheel in boxes of documents that are attached as exhibits. An exhibit is something you attach to the actual motion or the complaint or whatever it is, and it's to support what you're saying in your motion. And they come in with boxes of stuff.
So they have the money to do it.
They do. If anybody tells you that there's a disadvantage to being a plaintiff, that's the big disadvantage. The other side will eat you up.
Yeah.
And if you have to pay an hourly rate, they are going to really eat you up because they know it. And they will grind you out until you fold.
They'll bury you.
And they will. You know why they settle cases on the courthouse steps? People always hear that expression. You know why they do that? They've already run out of billable hours, except for the trial. And they don't want to do the trial because you could lose. You lose the potential of losing the client. In fact, I know I told this story before, but not every person listens to every one of these shows, so I do. Me too. I actually do play these the next day. I want to hear how bad I sounded.
Oh, come on. You sound
how
great.
How good I sounded. The bottom line was He told me he was representing one of the big insurance companies.
Yeah.
He said, I can't afford to lose. We were socially friendly. He was a thief and had no integrity. But socially, we were friendly. And I liked him personally. But he had no morality because he wanted to keep that client. That client, he had a couple of hundred lawyers working on their business. He said, if I lose enough of these cases, they're down the street because there's other law firms are looking to compete. They'll charge less. They'll overbill them a little less. They'll do whatever they're going to do.
We'll take them.
So the bottom line is there's these motions. So the public really needs to know what they are. So I explain in the book in layman's terms, what are these things? And how do you deal with them? Do you need one? A lot of times you don't. I would tell people in terms of a demurrer, I don't think much about demurrers. Unless it's a really qualified case that's justifiable. A demurrer is a mistake, to my way of thinking, because what you do is you give the other side an opportunity to fix the mistakes. Because generally when you rule on a demurrer, if you sustain the demurrer, meaning that you're agreeing with the party that's making the motion, you give the other side an opportunity to fix it. So what do? They go back and they fix it. Now you've educated them on where you're going, and they're going to fix it. Better you should keep your mouth shut, wait till the time of trial, and then make a motion on the pleadings or these other technical things that you can do to get the same result.
I've heard that many times.
But they love to run those bills up.
Of course.
And they will do it at the drop of a hat, and they'll run you around. So let's get to discovery in the remaining time we have today, because discovery is the most expensive part of most lawsuits. And I said I'd make the criminal discovery very, very short. You know the reason why it's very short?
I don't know, Judge. Tell me.
Because there is none.
Okay, well, there you go.
There's a case called Brady versus Maryland. And I give you the cases now. I've decided to do that because people who have an interest in the subject matter just go to Google. Look up Brady versus Maryland.
That's the one good thing about the internet is that you can just look up anything now, which is fantastic.
And I do.
I do too.
Sometimes people ask me legal questions. I don't know the answers.
You go look it up on Google.
I absolutely do. I said, let me call you right back. The phone is ringing.
Right. It's fantastic. I mean, the one good thing about the internet, I will say, is that you can look up anything and find out most anything.
So I tell people, look at Brady versus Maryland. It's a U.S. Supreme Court case. It deals with criminal discovery in the sense that you could call it discovery. It means that the prosecution must give you every piece of evidence they intend to use, and you as a defendant have an obligation to do the exact same thing. So there's more of an informal discovery. Civil cases, very different. And that's called a motion to produce. A motion to produce means you lay out all the things you want the other side to give you in form of written documents. It could be voluminous. I'll talk to you about a particular case right after the break.
All right, if you want to ask the judge a question, email him at askjudgeherb@gmail.com. Askjudgeherb@gmail.com. We'll be back after this.
NBC Talk Radio, 1050 AM, KCAA.
Did you ever meet a lawyer that was for the people? Someone who had the best interests of the people at heart? Herb Dodell has been a lawyer for more than 50 years and has been a Superior Court judge for 9 years, having presided over more than 9,000 cases. In this show, he will reveal the secrets of how things really work in the legal system, so you can maximize your position and benefit most when you're in trouble and need someone on your side to simplify the process for you. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
And if you want to know about rights of privacy, I've mentioned this in the shows that we did on that subject. Rights of privacy, cyberbullying, and all of that. And by the way, we're going to have Lisa Lee, who's an adult star, porn
Lisa
star.
Ann you're talking about?
Lisa Ann. Why am I calling Lisa Lee?
I don't know, but
Lisa Ann.
Lisa Ann. Wow.
Yeah.
We are?
Yeah, we're going to talk about cyberbullying.
When's she coming on?
In a couple of weeks.
Okay, cool.
And, you really want to know where it all starts from and what is the basic origination of Roe versus Wade. Just go and look up the case of Griswold, Griswold versus Connecticut. That's probably one of the first right of privacy, government intrusion, compelling interest, and things like that. That'll give you a start if you really want to do an intellectual exploration. That's a good place to start. It'll take you to Roe versus Wade, because Roe versus Wade cited Griswold.
We should get into that one show.
We will. That's going to be a hot subject right now.
Oh yeah, that's
as it winds to the Supreme Court, which it will. Although there's always a possibility that the Supreme Court will refuse to hear the case. It's called a writ of certiorari, C-E-R-T. I shouldn't do this one. I can't spell that.
Do you really think that the Supreme Court is not going to take that up? What's your gut feeling on that?
I don't have a gut feeling.
I think they're going to take it up. I mean, because these states are just so gung-ho, like Missouri and Alabama, Georgia. There's so many states that are just coming out with these anti-abortion laws that they're going to have to take it up.
Yeah, but you know, we have the Constitution and the legal system, which is Article 3 of the U.S. Constitution, really talks about some of these rulings, and it's called stare decisis, S-T-A-R-E, decisis means it's already been decided. And it may very well be that a justice like Kavanaugh, or even Gorsuch, who are considered conservatives, real conservatives, many of them may believe that it's been decided already and it's not time to go back and change just because you want to change it for political reasons. They may just say, I don't want to hear this writ. And so the Ninth Circuit or the Sixth Circuit or whatever circuit has made the decisions, it sticks.
Let me ask you a question, okay? I actually think Judge Roberts is the most reasonable judge on the bench, to tell you the truth. I don't think he's too far right, and I definitely know he's not too far left, but I think he's the one who's going to really be the decider of it. He's the Chief Justice. But what would happen?
He has the same vote. He's one vote.
I understand that, but he listen, I really think the other two, Kavanaugh and Gorsuch, or whatever the hell his name is, I think that's why Trump nominated them, and that's why they're on the bench, is because I guarantee you they said that they would take up the Roe versus Wade, even though they're not saying it to the American public.
Well, wink,
wink. You know what I mean?
Well, they were interviewed by the Federalist Society. I think it's called Federalist Society.
Yes, the Federalist.
They're real conservatives.
Yes, they are.
And they, I'm sure, vetted these people out.
Exactly.
And asked those very same questions.
Exactly.
That's what it came time for an interview before the Senate. They knew the right answers.
Yeah, but let me ask you a question. Okay, let's just say the Supreme Court takes it up and then rules for Roe versus Wade. Does the state of Alabama have to change their laws, or Georgia?
Yes, it's unconstitutional.
So then it would become, but isn't it unconstitutional right now for Alabama to do that?
Yes, it is. And that's the argument that's going to be made as it works its way up. See, there's 3 different tiers in the federal system for you folks who are interested in how the federal system works. It starts out with what they call the federal district court. There are district courts in all the states, and there's several in every state. The bigger the state, the more district courts you have. That's the trial court. The equivalent in California would be the Superior Court, which is the trial court in California. Then in this federal system, you go to the next step, which is called the Circuit Court of Appeals. I think there's 12. I'm not really sure. I haven't looked at it in a long time. And that's the appeal court for the federal system. And in the state courts, they're either called the Court of Appeals or appellate court, whatever they call it. And ultimately, there's a state Supreme Court and there's a U.S. Supreme Court. Those courts, the Supreme Courts, do not have to hear every case. It's discretionary. You have to file a petition to get their attention. The intermediate courts must hear the appeals as long as they're filed timely. They must hear them. It's not discretionary. But I wanted to get back to the notice to produce before we close for today.
All right.
I remember a case. It was involving Ticketmaster. I'll never forget it because my client at that time, this is going back 30, 40 years, was a psychiatrist. And he was accused of running up all these phony bills for these personal injury cases. He was working with some ambulance chaser type lawyer. And the notice to produce, we asked Ticketmaster to produce their records, $300,000. pieces of paper were produced. Sometimes the defense gets smart and they outsmart the plaintiff and they give them more than they're asking for, which means that the plaintiff's lawyers, are usually a paralegal, because that's what paralegals do, have to go through all of this information,
Minutia.
most of which is worthless.
Yeah.
Worthless.
Right.
So that's called a notice to produce. That usually is met with objections. Objections, it's not relevant, it's not material, not calculated to lead to the discovery of admissible evidence, it's privilege, whatever it is. And by the way, privilege is lost if you communicate that communication to a third party. So if you give your tax returns to the bank, you no longer have a privilege in those tax returns. They've been disseminated to a third person. And so other times they'll object, attorney-client privilege, whatever. And by the way, I wanted to mention this. People think that every conversation between an attorney and a client is privileged. Not so. There's what they call the criminal fraud exception. In California, I think it's 972. I'm not really sure about the number anymore. But if the communication was in furtherance of a crime or a fraud, no privilege. Lawyer has no privilege. And so just because you talk to your lawyer about it, if you're planning a crime, not covered. And so these requests for production are often met with lots of objections. The court requires you to do what's called now a meet and confer. Meet and confer means that you have to talk to the other side as to why they should do or not do whatever it is that you're asking for. And after that is done, a motion is made, usually to compel, or for what's called a protective order. A protective order says, look, this is harassment, this is overwhelming, whatever it is, and you may be able to get a court to narrow down the request. You can only ask for so many at a time. So that's one method of discovery called a request for production of documents. Another one is called a request for admissions. A request for admission is you send it to the other side and you say, admit that on such and such a date you were at such and such a place and such happened. And they have three choices: admit, deny, or say you haven't got enough information to answer either with an admission or a denial. So those are the choices. And the penalty, if you deny something that is later proven at trial, the party proving it at trial is entitled to what's called sanctions. It means you get the attorney's fees for having to go through the effort of proving something that should have been admitted by the other side. And in all the years I practiced, and even those on the bench, I never saw one of those motions to get the money for that you had to prove it. Never saw it, not once, even though it's in the code section and it's there. And so that's called a request for admission. Then the third is called an interrogatory. An interrogatory is just a fancy word for question. There are two types of interrogatories. One is called a form interrogatory. That's basically printed. The state judicial commission prints them up. They're a form, check the box kind of thing. And I think there's 53 of them in California. And it basically asks for your name, have you been known as, you've been arrested before, do you have insurance? Those are the general broad questions. Those are called form interrogatories. They're not very objectionable because they're form. The other ones are called special interrogatories. Those are handcrafted, or we refer to it in the legal world as manuscripted. They're written specifically for the case that you're dealing with. And they're asking for questions. Those questions are asking for specific material and specific information. And if the other side doesn't want to answer them, which happens regularly, you go through the same process of a meet and confer, and then you go to make a motion to compel. They file an opposition, you file a reply, and billable hours are generated. This is what this. I hate to be so overly cynical, but I am, I guess. But they're always looking for a billable hour. And they'll find a billable hour somewhere. And
what's the average cost of a billable hour?
I suppose it depends on where you are. If you're in Visalia, the hourly rate's going to be different than the rate you're going to be charging somebody in Century City.
All right, what's it for the Inland Empire, since we're in the Inland Empire? What do you think a billable hour for a lawyer would be?
For a defense lawyer?
Sure.
I'd say probably $2.25 to $2.75
an hour.
An hour, yeah.
And we're not talking $2.75.
No, we're not. And for the plaintiffs, who are on an hourly basis, look, there are some plaintiffs' lawyers that are getting $1,000 an hour. I know several of them that are doing that, getting $1,000 an hour.
Thieves.
And mediation, the mediators are charging $1,000 an hour.
Thieves.
Well, it depends on what you're going to get too. There are some of those people who charge those rates.
Yeah.
Get cases settled. Would you rather pay somebody $1,000 an hour, settle it, and get your money back?
If you could do it in an hour, yeah.
I tell you're not going to the bathroom on my time.
Yeah, that's right. No recess.
Hold it in. You're not,
no lunch.
But plaintiffs charge more than the defendants usually. Plaintiffs' lawyers charge more than the defendants.
Yeah, of course.
Because the defendants are in a competitive world, most of them.
Yeah.
I'm not saying everybody's an insurance defense lawyer, but if you're looking strictly at the insurance defense people, they're all pretty much within the same range because they're in competition. And if you're doing it for X dollars, the guy down the street will do it for X plus 10%.
That's why you got to look around.
But the other guy is smarter. He says, you know what? I'll agree to that. I'll take less. But then what does he do? He creates
bills you more.
No, he creates hours.
That's what I'm saying.
That's right. Exactly
He'll
right.
bill more hours. Yeah,
exactly. And what they do is they hire people right out of law school. See, insurance defense firms are different. It's not like you're getting somebody from Harvard. A lot of the people who go into insurance defense lawyering come from the smaller schools, the more correspondence type schools. Like Michael Cohen went to some place in Ohio.
Like Kim Kardashian's going to.
Whatever. She's going to be a great lawyer. She'll be a great lawyer.
Yeah, I'm sure she will.
I'm looking forward to it.
Mini skirt,
Well, we used to have a judge used to wear pink mini skirts.
Really?
Yeah, they threw her off.
Was she hot?
I remember. She was a nice looking girl.
Okay, all right, cool.
Blonde hair, pretty.
Okay, Judge.
But she wore pink. She wore pink a lot.
Oh my God.
But the law system is really very interesting for the public. Reading this book will give you a real fresh understanding.
Where do we get the book
at?
Where do we get the book?
Amazon.com.
What's it called again?
From the Trench to the Bench, Navigating the Legal System and Finding Your Spiritual Path Along the Way.
Along the way.
And you do. If you follow some of the rules, the spiritual principles in this book, life will change for you.
Amen.
It really will. It's proven. It's not a guess. So that's it for today, Gary.
Okay, well, congratulations on your new grandchild, and happy
I'm
birthday,
thrilled.
and all that good stuff.
Yeah.
And, we'll be back next week.
Okay, see you then.
KCAA Loma Linda, 1050 AM, 106.5 FM, and now 102.3